Welcome back to the deep dive. Today, we're tackling something fascinating, but definitely intricate: intellectual property law. Specifically, we're sort of pulling back the curtain on patent attorneys. The people who are really crucial for inventors and companies trying to protect their big ideas.
Absolutely crucial. The unsung heroes sometimes.
Right. So our guide for this deep dive is based on excerpts from 6 patent attorney interview questions from Kaplan. It really gives some great clues about what employers are actually looking for.
Yeah, it's a good source for that.
So our mission here is really to unpack what makes a great patent attorney. The key skills, the strategic thinking, whether you're maybe looking to hire someone or you're prepping for an interview yourself, or maybe you're just curious about why this role is so important today. This should give you some real insight. Okay, let's unpack this. Let's get into the nitty-gritty of what it takes.
And it's worth remembering, these aren't just, run-of-the-mill questions. They're specifically designed to look past the resume. They really dig into practical experience, how someone thinks strategically, even their temperament.
Temperament, that's interesting.
Yeah, because it's not just about knowing the technical stuff. These questions get at the soft skills too, like communication, negotiation, handling clients. It's the whole package.
That makes sense. So with that kind of framework, let's dig into these questions, see what they really tell us. We've sort of grouped them into 3 areas, starting with motivation, like what gets someone into this field.
Good place to start.
Okay, first question. What inspired you to become a patent attorney? The ideal answer, usually, it seems to touch on a passion for tech, for innovation, but also wanting that career in law.
Right.
And, liking the idea of working with inventors, with entrepreneurs, helping protect ideas and get them out there.
And what's really key there, I think, beyond just saying, I'm passionate, employers listen for how you connect that passion to the actual, sometimes tedious work.
The grind.
Yeah, exactly. It's not just the aha moment of invention. It's the patience needed for prosecution, dealing with rejections, constantly learning new technology. That real connection to the inventor's whole journey, that's what makes a difference. Helps avoid burnout, too. It's demanding work.
Absolutely. Endurance is key, which leads us straight into the practical side, right? The patent application process, which brings us to question 2. What is your experience with patent prosecution? This is where you gotta talk specifics, like drafting applications, filing them, responding to those office actions from the USPTO.
Ah, yes. Office actions. Every patent attorney knows those well.
Right, the Patent and Trademark Office. And handling interviews with examiners, plus knowing the laws, the regulations, what actually makes something patentable.
Yeah, that's absolutely fundamental. Patent prosecution is basically, well, it's how you build the legal protection around an idea, turning concepts into actual protected assets. And those office actions you mentioned, that's often where the real strategic work happens. Well, anyone can list the steps, maybe. But a good attorney explains why an argument didn't work initially, or what made an examiner interview successful beyond just, getting the patent. It shows strategic thinking when things get tough.
Right, thinking on your feet. So speaking of that experience, what's a common pitfall maybe when people try to explain their prosecution background?
Good question. Often I find candidates talk about what they did. I drafted this, I filed that, but not why or the impact. Like, how did your drafting maybe prevent future problems? Why was that specific argument in the office action the one that worked? It's about showing the decisions behind the tasks.
That's great advice. Show the strategy, not just the checklist.
Exactly.
Okay, moving on. This field changes constantly, right? So staying up to date is huge. That brings us to question 3. How do you stay current with changes in patent law and regulations? The source mentions the usual suspects: reading industry stuff, going to seminars, continuing education, being part of professional groups.
Yeah, and those are all important. But again, it's more than just listing activities. It's showing genuinely understand that patent law isn't static. It moves with technology, with court decisions.
So it's about demonstrating a habit.
A habit and maybe even foresight. Like, how are you thinking about future changes with things like AI, quantum computing? The lines are blurring. It shows adaptability, which is just critical in a field moving this fast.
Adaptability and problem solving when things do go sideways, which takes us to question 4. Can you give an example of a particularly challenging patent case you've worked on? Kaplan gives us a solid example here. A software patent, something about new encryption tech.
Yeah.
The challenge: USPTO rejected it initially, said it wasn't new, cited prior art.
The classic prior art rejection happens all the time.
Right. So the actions taken involved really working with the inventor, tweaking the claims, finding more evidence to show it was non-obvious, that legal hurdle.
Non-obviousness, yes. Key standard.
And the outcome, success. But it took several rounds of back and forth, the prosecution process you mentioned.
And that kind of story, that's gold in an interview. It shows everything. Legal skill, sure, but also persistence, strategic thinking, how you handle roadblocks. What I look for there is the analysis. Did they understand why it was rejected? And how did they pinpoint the angle, the non-obvious bit that finally worked? That's more than just following procedure. It's creative legal work.
Creative legal work. I like that. It's not just knowing rules, but using them smartly.
Precisely.
So you get the patent, great, but then comes defending it sometimes.
Oh, yes. The next chapter.
Which is question 5. What is your experience with patent litigation?
This covers things like drafting infringement complaints, doing discovery, depositions, those formal Q&A sessions under oath.
Which can be very intense.
I bet. And working with expert witnesses, knowing federal court rules, litigation strategy, it's a whole different beast. Totally different from prosecution. This is where you test the strength of that patent you work so hard to get. Litigation is how you defend those rights. If someone challenges them or infringes, it really is like a high-stakes chess match sometimes. An employer needs to know you can not only build the fort, but defend it too.
High-stakes chess, involving potentially millions and years of research. Puts it in perspective.
Definitely.
Okay, finally, let's zoom out. Global innovation. Question 6. What is your experience with international patent law? This means things like filing PCT applications. That's the Patent Cooperation Treaty, right? For getting protection in multiple countries.
Correct. A very important tool for global strategy.
And working with lawyers in other countries, knowing the differences in patent laws internationally, and navigating all that complexity.
Yeah, and that adds a whole other layer. Innovation doesn't stop at the border these days. Protecting an idea often means protecting it globally. So this question isn't just about knowing different rule sets. It's about understanding the strategy needed for different legal systems, different cultures even. It shows a global mindset.
A global mindset. Okay, so bringing it all together, what does this deep dive tell us? What does it mean for, our listeners? It really highlights just how broad the skill set is for a patent attorney. You need the tech background, the sharp legal mind, the problem-solving skill.
And the people skills, don't forget those. Communication, client management.
Absolutely. It's this unique blend. So whether you're looking to hire, trying to become one, or just fascinated by innovation, understanding these questions and what's behind them is pretty valuable.
Invaluable, I'd say.
So as we wrap up, here's something to think about. Building on all this, we've talked about the expertise needed now, but think about the future. Technology is moving so fast. We've got AI creating things, quantum computing on the horizon, biotech breakthroughs. What kind of future innovations do you think will really push the limits of our current patent laws? And what new skills, what new competencies will patent attorneys need to protect them effectively? Something to chew on.